Honorable the President of India, Srimati Draupadi Murmu ji, Justice Vikram Nath, Judge Supreme Court of India, and Executive Chairman, National Legal Service Authority, my esteemed sister and brother judges from the Supreme Court of India, Shri Arjun Ram Meghwal ji, Honorable Minister of State for Law and Justice, distinguished Chief Justices and senior judges from the apex courts of Nepal, Sri Lanka, Bhutan, Kenya, and Mauritius. We have former Judge of the Supreme Court of Nepal, Justice Anil Kumar Sinha, who is presently looking after the affairs of the country as a law minister. Justice V.N. Khare, Justice Kher, Justice Ramana, and Justice Bhushan Krishnan Gavai, Honorable the former Chief Justice of India, Honorable former Judges of the Supreme Court of India, Sri R. Venkatramani, Attorney General for India, Justice D.K. Upadhyay, Chief Justice Delhi High Court, and other judges from the High Court of Delhi, Sri Tushar Mehta, Learned Solicitor General of India, Learned Additional Solicitor General of India, Sri Manan Kumar Mishra, Chairman Bar Council of India, Sri Vikas Singh, Senior Advocate and President, Rahul Mishra, Vice President, Pragya Baghel, Secretary and other office bearers of the Supreme Court Bar Association, Sri Vipin Nair, President, Sri Anil Sharma, Vice President, and Sri Nikhil Jain, Secretary of the Supreme Court Advocates on Record Association, Secretary General, Registrars and other officers of the Supreme Court, distinguished senior advocates, members of the Supreme Court Bar Association, registrars and other officers from the visiting friendly nations, dear law students, ladies and gentlemen, Namaskar. It is my proud privilege and profound pleasure to stand before this distinguished and illustrious gathering as we commemorate 76 years of our venerated Constitution coming into force. Allow me to commence on a resonant and evocative note by recalling the wisdom of Begum Ezaz Rasool, who was one of the 15 women members of the Constituent Assembly and an everlasting source of inspiration, and one of the distinguished women whose contributions enriched the deliberations of our Constituent Assembly. She said, and I quote, "A constitution is judged by the spirit in which it is worked. It is judged by the manner and method of its implementation. I hope and pray," this is what she said, "that the implementation of this constitution will be such as to enhance the prestige of our motherland and make her a dynamic force that will bring together all nations of the world within the orbit of an enduring peace." Though decades have passed, this powerful statement echoes with undiminished force. It reveals how the framers envisaged a constitution both supple enough to adapt to changing realities and visionary enough to position India not only as a thriving nation but also as a moral and constitutional compass for the world. This expression has, in many respects, proved remarkably prescient. Our Constitution has guided us from the uncertain steps of a young nation finding its footing to the confident stride of a country now counted among the world's largest economies and regarded as a force of consequence. Over these 76 years, industries have taken shape, policies have matured, economic architecture has been carefully constructed, legislative and regulatory framework have evolved with remarkable sophistication, and technology has advanced a breathtaking pace. Yet, through all this transformation, one constant has anchored our progress, and that is the Constitution has remained our enduring grundnorm, the stabilizing force that has allowed change without chaos and growth without drift. A central reason for this abiding ability has been the judiciary's unwavering dedication to reading the Constitution in harmony with evolving realities, consistently upholding its duty as the Constitution's vigilant guardian. In the decades since our Constitution came into force, the judiciary has continuously evolved and breathed life into the words inscribed in it, guided by the single-minded objective of ensuring that justice eludes no one. Over these years, we have expanded the contours of Article 21, infused renewed meaning into the fundamental duties and the directive principle of state policy, and enabled public-spirited and aggrieved individuals to approach constitutional courts directly for the vindication of their rights. However, I am not suggesting that our challenges have been exhausted or that our aspirations have reached their limit. As the old adage reminds us, when one climbs a mighty mountain, one discovers only higher peaks still to be scaled. As we mark 76 years of our Constitution's existence, it is imperative that we reinvigorate our pursuit of the constitutional promise of access to justice, which is a foundation upon which all other rights rest. Without such access, liberties become ornamental, and constitutional guarantees lose their resonance in the lives of ordinary people. This commitment is embedded at the very core of our constitutional design through Articles 32 and 39A, which make access to justice both explicit and indispensable. Our framers recognized that a constitution which proclaims rights without providing avenues to enforce them may not be a true testament of justice. It is for this reason that Article 32 has been described as the heart and soul of the Constitution, and why the duty to safeguard access to justice rests squarely upon the Supreme Court and High Courts as guardians of the constitutional order. It is against this constitutional backdrop that we must consider what is required to give this guarantee meaningful effect. If access to justice is our moral and constitutional North Star, then predictability, affordability, and timeliness form its core supports. Despite that, when we look closely at the functioning of our justice delivery system, there is still a disquieting gap between the constitutional vision and the experiences of many, particularly those on the margins for whom the ideals of access to justice remains elusive due to exorbitant cost, language, distance, and delay. These barriers weaken the very overarching goal we seek to protect, and in doing so, magnify existing inequalities. I believe that veritably realizing the precept of access to justice is an act of constitutional fidelity, and the first step in that direction must be through the augmentation of judicial infrastructure in aid of effective justice delivery. By judicial infrastructure, I speak not only of physical infrastructure or facilities, but also of the technological, administrative, and human systems that enable justice to function. This infrastructure is the bedrock on which meaningful reform rests and forms an indispensable element of constitutional performance. While the judiciary remains the sentinel of the Constitution, we must acknowledge that the justice system extends beyond formal adjudication. It requires a conceptualization of complementary pathways that are accessible, credible, and firmly anchored in the constitutional values. In particular, I wish to underscore that one of the most transformative developments in contemporary jurisprudence has been the emergence of mediation as a central pillar of our justice delivery system. Mediation opens pathways not through adversarial triumph but through cooperative resolution. It is cost-effective, participatory, and deeply humane. When supported by well-designed mediation centers, trained professionals, structured procedures, and robust digital platforms, mediation has the potential to reshape our dispute resolution culture. It can easily take care of dependency, enhance public confidence, and repair relationships in ways that litigation seldom permits. Above all, it brings justice closer to the people by offering a process that is less intimidating, more efficient, and genuinely responsive to individual needs. I take great pride in noting that the recently organized Mediation for Nation drive has garnered substantial step in promoting mediation as a lucrative and expeditious means of resolving pending matrimonial, motor accident, and commercial disputes. As part of this initiative, we have also developed a comprehensive 40+ hour online mediation training module to equip participants with the requisite skills, thereby enabling them to meaningfully contribute to this evolving vision. Alongside mediation stands the broader architecture of arbitration and other forms of alternative dispute resolution. Institutionalized arbitration has the capacity to transform not only domestic dispute resolution but also India's global legal standing. We have established world-class arbitration centers, embraced international best practices, and ensured consistent judicial support for arbitral autonomy. India is thus steadily positioning itself as a preferred destination for international dispute resolution. This synergy among courts, ADR, and mediation is, in my view, where India's judicial future truly lies, and technology is the connective tissue that binds this vision together. Digital filing, virtual hearings, online transcript software, multilingual platforms, and modern case management tools have already begun to democratize access to justice. Nevertheless, technology must still be deployed with sensitivity and should remain inclusive, particularly for those who lack resources or connectivity. When I speak of harnessing technology within the judicial system, it is equally essential to recognize the role of international cooperation in shaping both our technological and institutional progress. As the Indian judiciary has successfully employed technology as a part of ongoing efforts to advance the goal of providing access to justice for all, we remain committed to sharing our practices and expertise with friendly nations. It is my conviction that the Committee of Courts should no longer be regarded as an abstract diplomatic ideal. It must be understood as a practical conduit for shared learning, mutual strengthening, and collective advancement. Ultimately, the constitutional promise of access to justice cannot be achieved through one measure alone. It is fulfilled by a justice system working in concert, anchored in resilient infrastructure, enriched by technology, expanded through institutionalized ADR, and led by a judiciary steadfast in its constitutional mandate. The time is also ripe for us to reinforce predictability in our judicial approach. One constructive way forward, in my opinion, can be the evolution of a uniform national judicial policy, an institutional framework that encourages coherence across jurisdictions so that our courts speak with clarity and inconsistency. It is high time we minimize unpredictability and avoidable divergence that may arise simply because there are 25 high courts or multiple benches in the Supreme Court. Justice cannot resemble a set of instruments producing harmonious notes in isolation, but discordant sounds when played together. Instead, we must strive for a judicial symphony, one rhythm expressed in many voices and languages, but guided by a common constitutional score. On this historical day, we are reminded that the Constitution is not self-executing. It lives through our institutions, our citizens, and our collective determination to refine, rethink, and rebuild. As I quoted earlier, I am reminded that the framers entrusted us with a document of extraordinary breadth and imagination, believing that future generations would build a vibrant India capable of standing as a formidable presence on the global stage. Let us honor that trust. Let us continue to work on building a justice system that resonates with every individual who seeks its protection and remains faithful to the principles enshrined in our Constitution. Let us reaffirm that the Constitution gives us the strength to maintain democracy and proclamation of rights, and not only it also gives us the capacity to secure such rights. Thank you very much for